doctrine of separation of powers, which is the dispersal of such sovereign functions to the traditional executive, legislative, and judicial organs of government. A literal interpretation of the doctrine can theoretically lead to the conclusion that there is such a conflict. Under this myopic view, the existence of regulatory agencies with hybrid powers is not in harmony with the doctrine and the trichotomy that was set up by our constitutional system. The constitutional position of regulatory agencies is an issue that has engaged the attention of legal scholars. How are we to classify these ubiquitous agencies in the light of the dominant principle of separation of powers? In the first place, no matter how critical their role is in governance, they do not constitute a fourth branch in our constitutional order. There is no such thing as a fourth branch. Secondly, because of their hybrid functions, they cannot be regarded as strictly or exclusively belonging to the executive, legislative, or judicial branches of government. So how are we to explain their place in our constitutional system? The following observations of Professor Jaffe and Nathanson, one of the more respected authorities in administrative law, are enlightening. According to Professor Jaffe, the separation of powers principle is a fundamental and valid dogma of our constitutions. The object is the preservation of political safeguards against the capricious exercise of power, and incidentally, it lays down the broad lines of an efficient division of functions. Its logic is the logic of polarity rather than strict classification. History, convention, and constitutional mandate definitely allocate certain functions to one or another of the three great organs. But in many crucial instances, where there is pressure for the transfer of old, or the creation of new functions, or for the better implementation of old ones, the logical implications of the principle are conflicting. Our constitutions recognize the legislative as the organ of widest lawmaking competence. Our courts consequently presume that legislative acts are constitutional. If, therefore, the legislature has seen fit to create an organism, notice how he addresses these agencies as organism. If the legislature has seen fit to create an organism for the transaction of public business, its validity should be sustained if one among competing logical implications reasonably supports it. At such points, the theory of separation is logically too infirm to condemn any sensible or convenient arrangement. We should, in sum, keep in mind that the great end of the theory is by dispersing in some measure the centers of authority to prevent absolutism. It is not eternally to stratify our government arrangements in the particular mold of 1789 or any other day. Unquote. The prevention of absolutism and the capricious exercise of the sovereign powers of the state being the ultimate objective of allocating such powers to the three traditional organs of the government, It stands to reason then that if there are existing control or checking mechanisms that can keep the regulatory agencies within legal bounds in the exercise of their hybrid functions, then the existence of such agencies can be reconciled with the doctrine of separation of powers under our constitutional framework. As shall be pointed out subsequently, there are such control or checking mechanisms, although with varying efficacy. This brings us to rulemaking and the non-delegation doctrine. The basic idea behind the non-delegation doctrine is that since the Constitution has conferred upon the legislature the power to make laws, the latter cannot evade responsibility by delegating such power to some other body or agency. As explained by the Supreme Court in the 1908 case of United States versus Barrias, the non-delegation doctrine is based on the ethical principle that such delegated power constitutes not only a right but a duty to be performed by the delegate by the instrumentality of his own judgment, acting immediately upon the matter of legislation and not through the intervening mind of another. Conventional legal thinking considers the delegation of rulemaking power to administrative agencies as an exemption to the non-delegation doctrine. Judicial decisions perfunctorily point out that what is permissible is merely the delegation to implement the law. Thus, rulemaking has been characterized as subordinate legislation, to denote the idea that it cannot transcend the limits of its statutory authority and the rules promulgated cannot be inconsistent with the law. That rulemaking is subject to the control of the legislature is too well settled in administrative law to require an extended discussion. Nevertheless, the often quoted judicial declaration that the power to make the law cannot be delegated should not be too narrowly or literally construed, as it would obscure the reality that regulatory agencies do in fact make laws. Rulemaking is legislative in character. When the rules promulgated are within the scope of the rulemaking grant, and when the legal requirements for the valid exercise of the rulemaking power are observed, such rules, according to settled jurisprudence, have the force and effect of law. This explains why the Supreme Court, in the leading case of Cañada versus Tubera, which up to 2010 has been reaffirmed by the Supreme Court, has ruled that due process requires not only laws but also rules and regulations, except interpretative rules and internal rules to be published in a newspaper of general circulation before they become effective. Moreover, under the Administrative Code of 1987, or EO 292, which was promulgated into law by then President Corazon Aquino at the time when she was still exercising legislative powers. That's why it's denominated as EO 292. But the more popular label of this law now is the Administrative Code of 1987. And according to this code, rules take effect 15 days from the date of filing with the UP Law Center. Pursuant to the separation of powers and the non-delegation doctrines. Jurisprudence has developed a test to determine when the delegation of power to agencies is permissible. In the case of Pilais versus Auditor General, a 1965 case where the Supreme Court declared as unconstitutional the power delegated to the President under Section 68 of the previous revised administrative code to create municipalities in the guise of fixing boundaries. The court laid down the so-called completeness test. Through Mr. Justice Roberto Concepcion, the court declared that although Congress may delegate to another branch of the government the power to fill in the details in the execution, enforcement, or administration of a law, it is essential to forestall a violation of the principle of separation of powers that said law be complete in itself, must set forth therein the policy to be executed, carried out, or implemented by the delegate, and fix a standard, the limits of which the delegate must conform in the performance of his functions. Indeed, without a statutory declaration of policy, which is the essence of every law, and without the aforementioned standard, there would be no means to determine with reasonable certainty whether the delegate has acted within or beyond the scope of his authority. Hence, he could thereby arrogate upon himself the power not only to make the law, but also, and this is worse, to unmake it by adopting measures inconsistent with the end sought to be attained by the Act of Congress, thus nullifying the principle of separation of powers and system of checks and balances, and consequently undermining the very foundation of our Republican system. Well, as explained by the Supreme Court, this so-called completeness test appears to be workable as a device to prevent arbitrariness in the exercise of delegated powers. On closer analysis, however, it is in the fixing of standards that the functional value of this test can be seriously questioned. It is considered that if the standards are sufficiently definite or specific, the exercise of discretion, to borrow the felicitous language of Justice Cardoso, can be, quote, canalized within the banks that keep it from overflowing. By the way, I have to digress a little bit because I find it uncomfortable that this famous quote of Cardoso has been attributed to Justice Holmes by a lot of commentators. To be accurate about it, this belongs to Justice Benjamin Cardoso in his famous dissenting opinion in the landmark case of Panama Refining Company. On the other hand, if the standards are broad or vague, what could result is unbridled discretion in the exercise of delegated powers. In the history of delegation cases in the Philippines, broad standards such as interest of law and order, public interest, justice, and substantial merits of the case, among others, have been considered by the Supreme Court as sufficient standards that could withstand an attack on the constitutionality of the delegation of powers. The inability of the legislature to provide the specific standards in every case of delegation of power is not difficult to discern if we consider the fact that administrative agencies operate in different areas which are subject to conditions and policy considerations with varying degrees of susceptibility to specific standards. It has been pointed out that the laying down of definite standards should take into account the number, vagueness, and degree of potential conflicts among the policy indications which the legislature wants to be accommodated and the rate of change and movement in the facts concerning such policies. In instances where the fixing of specific standards cannot be done, Congress, just the same, proceeds with the delegation of power by providing broad, quite often vague standards, rather than withhold it and thereby frustrate the implementation of a desired legislative policy. Notwithstanding the difficulty involved in the fixing of specific standards, the Supreme Court has taken a perspective which acknowledges that the delegation of powers to regulatory agencies is an imperative in our modern society. Consequently, it has assumed a liberal attitude in resolving issues on sufficiency of standards. I need not catalog the long line of cases where this posture of liberality is quite manifest. Viewed in the light of the inability of the legislature to supply definite or specific standards in all instances of delegation of power, and considering the liberal posture of the Supreme Court in resolving questions on sufficiency of standards, an important issue pertaining to the efficacy of the non-delegation doctrine as a tool to curb the capricious exercise of the delegated power arises. It is noteworthy that Professor Kenneth Davis, one of the most recognized authority in administrative law, considers the non-delegation doctrine as a failed doctrine. He advocates its modification into a judicial tool that can effectively control administrative discretion. From his perspective, the non-delegation doctrine can and should be altered to turn it into an effective and useful judicial tool. Its purpose should no longer be either to prevent delegation of legislative power or to require meaningful statutory standards. Its purpose should be the much deeper one of protecting against unnecessary and uncontrolled discretionary power. The focus should no longer be exclusively on standards. It should be on the totality of protections against arbitrariness, including both safeguards and standards. The key should no longer be statutory standards. It should be the protections the administrators in fact provide, irrespective of what the statutes say or fail to say. The focus of judicial inquiries thus should shift from statutory standards to administrative safeguards and administrative standards. As soon as that shift is accomplished, the protection should grow beyond the non-delegation doctrine. A much broader requirement, judicially enforced, that as far as is practicable, administrators must structure their discretionary power through appropriate safeguards and must confine and guide their discretionary power through standards, principles, and rules. In addition to the modified non-delegation doctrine, Davis is also of the view that due process and the void for vagueness principle as applied to administrative policy can likewise be utilized to enable the courts to require the articulation of administrative standards and safeguards. We are now in year 2011, and I have yet to come across a decision of our Philippine Supreme Court that could be discerned as a movement towards this direction. The conventional thinking that was displayed in Elias versus Auditor General prevails up to today. Perhaps it's about time that this matter be looked into by magistrates of our high tribunal. Now, concerning the limitations of the rulemaking power. Being in the nature of subordinate legislation, administrative rulemaking is subject to certain limitations. The rulemaking grant is not a license for the agency to promulgate in the rule. Aside from being authorized by law, the rule must not be inconsistent with the law or the Constitution. It must likewise be reasonable. This is apparently to comply with the requirements of substantive rather than procedural due process. And it must be germane to the purpose of the law. Agency perception regarding the desirability of the rule or its possible beneficial effects is immaterial where the rule is shown to be inconsistent with the law. The rule is void and can be successfully challenged in court. The provision in EO 292 on effectivity of rules and public participation through notice and hearing must be highlighted as it serves to provide safeguards that could maximize fairness in rulemaking. It is now a requirement for effectivity that 3 certified copies of every rule shall be filed with the University of the Philippines Law Center. Moreover, it is expressly provided that each rule shall become effective 15 days from the date of filing, unless a different date is fixed by law or specified in the rule in cases of imminent danger to the public health, safety, and welfare, the existence of which must be expressed in a statement accompanying the rule. This provision should be harmonized with the ruling in Centennial versus Rivera, that laws and rules take effect 15 days from publication. Notice the difference. In the administrative code, the rules take effect 15 days from filing. Centennial says they take effect 15 days from publication in a newspaper of general circulation, unless otherwise provided by law. So under the Administrative Code of 1987, rules take effect 15 days from the date of filing. On the other hand, Centennial requires publication in a newspaper of general circulation. Suppose a rule was published in a newspaper of general circulation, but was not filed in the UP Law Center. And the official, one of the officials involved in the filing of rules here in the UP Law Center has confided to me that some agencies have already enforced the rules, even if they have not yet been filed with the UP Law Center, on the strength of the alleged publication in a newspaper of general circulation. So, suppose a rule was published in a newspaper of general circulation, but was not filed in the UP Law Center. Will it take effect 15 days from publication? Conversely, if it was filed in the UP Law Center but was not published in a newspaper of general circulation, will it take effect 15 days from filing, as provided in the Administrative Code of 1987? Subsequent decisions of the Supreme Court, which affirmed Tanyada, require for the effectivity of rules both publication and filing. This much we can discern from the rulings up to 2010. The Supreme Court did not say that publication is sufficient. Neither did it say that filing is sufficient. The message was that for the effectivity of rules, you have to satisfy both filing and publication requirements. So what does this mean? The Supreme Court did not elaborate. But apparently, if you analyze it, this means that if either the publication or filing of the rule comes ahead of the other, the effectivity of the rule has to wait until the other requirement is complied with. That is the only way by which you can say that you have followed the decisions of the Supreme Court that both filing and publication must be complied with. On public participation, it is now a requirement that an agency shall, as far as practicable, publish or circulate notices of proposed rules and afford interested parties the opportunity to submit their views prior to the adoption of any rule. The importance of public participation in rulemaking cannot be overemphasized. It must not be forgotten that administrators who wield rulemaking powers are not elected representatives of the people who can be changed by the electorate during elections. These administrators are appointed public officers without a constituency, and as a general rule, cannot be removed from office except for cause as provided by law and after due process. If they make rules unilaterally without the benefit of public participation, there is greater probability of abuse in the exercise of the rule-making power. In the making of laws in Congress, public participation is ensured through the public hearings conducted by the different congressional committees and through the activities of various lobby or pressure groups. There is no reason why public participation should not be made an integral part of the rule-making process. By allowing the public to submit suggestions or counter-proposals to a proposed agency rule, the agency can take a second sober look at its own proposed rule and, if need be, accommodate input from the public in the final shaping of the rule to be adopted. One of the significant innovations introduced by the Administrative Code of 1987 is the provision that in the fixing of rates, no rule or final order shall be valid unless the proposed rates shall have been published in a newspaper of general circulation at least 2 weeks before the first hearing thereon. This is the law, it's in the code. But I was telling my students in administrative law that one day while I was driving home and listening to the news, there was the statement from the newscaster that representative so-and-so wants to file a bill in Congress to make it compulsory among administrative agencies with rule-making power or rate-fixing power to conduct public hearings before adopting the final order of rule fixing the rate. So I told my students that perhaps that representative is not to conversant with the Administrative Code of 1987, because there's no need for it to file a bill. It's already in the law since 1987. That before the agencies can fix rates, there must be publication of the proposed rate in a newspaper of general circulation at least 2 weeks before the first hearing thereon. So if you analyze the provision in the code, there are two requirements. One, publication. Number two, a hearing. This is really in harmony with the principle of public participation, which is now the dominant policy in administrative rulemaking. Besides, rate fixing is legislative in nature. However, there are instances when rate fixing assumes a quasi-judicial character. This happens according to the Supreme Court in the leading case of VIGA, Electric Light Company Incorporation versus Public Service Commission. When the rate fixed applies exclusively to one enterprise or entity and is based on a finding of fact, in which case due process requires notice and hearing. However, when the rate to be fixed applies to all entities or enterprises of a given kind, rate fixing becomes legislative in character. And unless the law requires otherwise, notice and hearing may be dispensed with. That qualifier, unless the law qualifies otherwise, is what prevails now. Because with the adoption of the policy of public participation in rate fixing, proposed rates of legislative character are now required to be published in a newspaper of general circulation before the first hearing. So, what we have is a case where either if rate fixing is to be applied only to one entity, you classify it as quasi-judicial. If it applies to all entities, you characterize it as legislative. It doesn't matter. There has to be notice and hearing. That is the significant contribution of the Administrative Code of 1987, amplifying further the implications of the holding of the court in the leading case of Vegan Electric Light Company versus Public Service Commission. This brings us to the judicial function of administrative agencies. If rulemaking is viewed as subordinate legislation, the judicial function of administrative agencies is characterized as quasi-judicial. However, it must be stressed at the outset that when agencies decide cases within their jurisdiction, they are truly exercising the judicial function, just like the regular courts. The essential or constitutive elements of the judicial function may be reduced to the following. First, a competent tribunal. Second, a case or controversy. Third and last, a law to be applied to resolve the case. Now, when an agency exercises its adjudicatory power to decide a case within its jurisdiction by applying the law which it also administers, all of these elements concur. Thus, when there is, for instance, an unfair labor practice controversy, the case must be filed with the National Labor Relations Commission because it is the competent tribunal to decide the case by applying the pertinent provisions of the Labor Code. So why use the term quasi-judicial to describe the adjudicatory power of the agencies? The usage of the term quasi-judicial can be explained by the following considerations. First of all, these agencies are not regular courts and are not part of the judiciary. They are creations of the legislature and they exercise delegated powers granted in the enabling statutes. In addition, the quantum of evidence in administrative proceedings is only substantial evidence, or such relevant evidence which a reasonable mind will accept as adequate to support the conclusion. While in civil and criminal cases, it is preponderance of evidence and proof beyond reasonable doubt, respectively. Moreover, although these agencies can issue subpoenas, writs of execution, and even issue contempt citations when such power is expressly granted by law, they do not strictly observe the technical rules of evidence and procedure in the conduct of their proceedings. The inapplicability of the technical rules of evidence and procedure in administrative proceedings is based on a laudable purpose. Unlike the regular courts, which move rather slow, with due apologies to the judges and justices in attendance, administrative agencies are created to act with dispatch and flexibility. Whether the reality matches this grand objective is, of course, an entirely different matter. It would be interesting to validate by empirical research the growing impression that many quasi-judicial agencies act like courts of law, forgetting the need to act with speed and flexibility. It is also important to take into account that in many instances, the administrators who wield adjudicatory powers are not members of the bar and therefore not conversant with the highly technical rules of evidence and procedure. The Supreme Court had the opportunity to comment on this matter in a case involving the Board of Examiners for Surveyors. And the Court noted that a rule so long respected, because it is buttressed upon reason and authority, is that the technical rules of court practice, procedure, and evidence are not to be applied with rigidity in administrative proceedings. We should have in mind the nature of administrative bodies, the character of the duties they are required to perform, the purposes for which they are organized, and the persons who compose them. Here we are concerned with members of a board of surveyors, technical men but not necessarily trained lawmen. In this posture, it is quite reasonable to assume that their proceedings may not be conducted with a degree of exactness or such scrupulous observance of the complex technical rules expected in a legal battle before a court of justice. Their acts should not be measured by the same yardstick exacted of a judge of a court of law. So much leeway is given an investigating administrative body. To be sure, there are many administrators who are required by law to be members of the bar. This is especially true in cases where their adjudicatory powers cannot be exercised effectively without knowledge of law and procedure. But this is not a guarantee that they will conduct their proceedings swiftly and expeditiously without being hampered by the rigidities of the rules on evidence and procedure. Having emphasized the need for acting with dispatch and flexibility, we must hasten to add that agencies cannot take shortcuts and disregard the fundamental requirements of procedural due process. In the landmark and frequently quoted case of Angtibay versus Court of Industrial Relations, the Supreme Court enumerated the following cardinal primary rights or requirements which must be respected in administrative proceedings. Number one, the right to a hearing. Two, consideration by the agency of the party's evidence. Three, the agency's decision must have something to support it. Four, the evidence to support the finding or conclusion must be substantial. Five, the decision must be rendered on the basis of the evidence presented at the hearing, or at least contained in the record and disclosed to the parties affected. Six, the agency must act on its own independent consideration of the law and facts of the case, and not simply accept the views of a subordinate in arriving at the decision. And finally, number seven, the decision of the agency must be rendered in a manner that will enable the parties to know the issues involved and the explanation or reasons for the decision. This last requirement is what we might call a reasoned decision, which usually includes a discussion of the facts, issues, and the law upon which the decision is based. The principle of procedural due process embodies the idea of fairness. In dispensing fairness, however, to the parties, the principle itself provides elbow room or flexibility to quasi-judicial agencies. Thus, unless the law expressly requires a formal evidentiary hearing, agencies can just require the presentation of position papers, affidavits, and other written presentations upon which they will base their decisions. What is important is the opportunity to be heard. And as long as the parties were given the opportunity to explain their side, a formal hearing is not necessary. At the beginning of the lecture, I gave special emphasis on the control or checking mechanisms of an administrative rulemaking and adjudication. And permit me to discuss this very briefly before I conclude this lecture. It will not be long. We may end this lecture and proceed to the open forum. A full-blown discussion of the checking or control mechanisms over administrative rulemaking and adjudication would require an extensive analysis of the relationship of administrative agencies with the executive, legislative, and judicial branches of government. As previously mentioned, these agencies cannot be classified as exclusively belonging to any of the three branches. However, these traditional organs of government do exercise control in varying degrees over the exercise of administrative power. But due to our limited time, we can only briefly discuss the ways by which the three branches can check the unauthorized or capricious exercise of power by administrative agencies. On the part of the President, the executive power that is vested in him by the Constitution enables him to exercise supervision over the entire bureaucracy and see to it that the laws are faithfully executed. He is likewise authorized, and this is more critical or crucial, he is authorized to exercise control, the word is control in the Constitution, over the executive departments, bureaus, and offices. This means that insofar as departments, bureaus, or offices in the executive department which exercise rulemaking and adjudicatory powers, their actions or decisions can be changed, altered, or modified by the President. But with regard to agencies created by Congress, the President exercises control only when the enabling statutes expressly granted such power to him. Otherwise, if the law is silent, he cannot exercise control as the intention of Congress is clear that he cannot review the actions or decisions of these agencies. From the perspective of the legislature, its oversight power over the agencies can be utilized as a control mechanism. Theoretically, and I use the word theoretically advisedly, through the creation of oversight committees, agency operations are monitored or supervised to ensure that the exercise of delegated powers is in accord with legislative policies. On closer analysis, however, lack of time, expertise, and organizational aptitude for effective and continuing supervision, the very same factors that compelled the delegation of rulemaking and adjudicatory powers to the agencies substantially diminish the functional value of these oversight committees as checks to administrative actions. Neither can we realistically consider the congressional power to conduct investigations in aid of legislation as a potent check on agency abuse or capriciousness in the exercise of their powers. While the Constitution mandates that these investigations be conducted in aid of legislation, some naughty minds insist that they are conducted in aid of re-election. Legislative history shows that quite a number of these investigations are focused on the past conduct of public officials who are suspected of having violated laws already in existence and hardly amenable to further amendments. Take the case of the anti-graft and corrupt practices in conjunction with the crimes committed by public officers in Book 2 of the Revised Penal Code, together with all the other laws like unexplained, forfeiture and seizure of unexplained law. Congress, through all the years, have blocked all the loopholes so far as the matter of preventing graft and corruption. It is not, I think, in our society today, it's not a case of coming out with more laws to curb graft and corruption. I think it's a question of political will, matter of eradicating corruption. So, what in effect they are doing, assuming the role of prosecutors or investigators, because oftentimes the end result of this investigation is recommendations to the Office of the Ombudsman for criminal prosecution of the officials who were investigated. Moreover, these investigations are not undertaken on a regular basis, and they are mostly confined to major or sensational cases of graft and corruption. Clearly, legislative investigations in aid of legislation is not an effective tool to prevent administrative misbehavior. Now, as to the Nondelegation Doctrine, we have noted earlier that the fixing of legislative standards in the enabling statutes of agencies can only be considered as an effective method of checking agency action when such standards are sufficiently definite or specific. Broad or vague standards are open invitations to absolute or unfettered discretions which may or may not be exercised for the public interest. It is, however, the rules of administrative procedure enacted by Congress which can help prevent uncontrolled discretion. It is noteworthy that Book 7 of the Administrative Code of 1987 contains provisions which prescribe procedural rules to be commonly observed by agencies in administrative rulemaking and adjudication. if strictly followed, these rules can further enhance the opportunity to be heard of the parties affected by the agency action, thereby ensuring their right to due process. It is the judiciary, and this should be a message that will perhaps be to the approval of our guests from the judiciary. The judiciary offers the most effective check on agency action through its power of judicial review. While the executive and legislative branches can control administrative rulemaking and adjudication only to a certain extent, the courts, through the various modes of judicial review provided in the rules of court, can better control agency behavior to ensure that it does not exceed the limits set by law. Undoubtedly, judicial review offers the most direct way to check capriciousness in the exercise of administrative power, and it provides immediate relief through the devices of TROs and injunctive orders to the adversely affected parties. In evaluating the efficacy of judicial review as a checking device over agency action, two major issues must be taken into consideration. The first issue is a threshold issue as it relates to its availability. If judicial review is available, the next issue that must be addressed pertains to the scope or extent of such review. Regarding the issue of availability, it is appropriate to ask at this point whether or not judicial review is available in cases where the enabling statute of the agency does not expressly provide for such review. Should the silence of the law be interpreted to mean that the intention of Congress is to withhold judicial review, the Supreme Court has answered this question in the negative in a case where the enabling statute did not expressly provide for judicial review. The court held that it is generally understood that as to administrative agencies exercising quasi-judicial or legislative power, there is an underlying power in the courts to scrutinize the acts of such agencies on questions of law and jurisdiction, even though no right of review is given by the statute. The purpose of judicial review is to keep the administrative agency within jurisdiction and protect substantive rights of parties affected by its decisions. It is part of the system of checks and balances, and which restricts the separation of powers and forestalls arbitrary and unjust adjudication. Judicial review is proper in case of lack of jurisdiction, grave abuse of discretion, error of law, fraud, or collusion. Notwithstanding the inherent power of the courts to scrutinize the acts of administrative agencies on questions of law and jurisdiction, a party seeking intervention to protect his rights adversely affected by agency action must satisfy the requirements imposed by the doctrines on standing to challenge, or locus standi, exhaustion of administrative remedies, and ripeness before the reviewing court can take cognizance of his case. Without going into the intricacies of the law on standing, it can be stated that the fundamental idea behind it is that one who is in fact adversely affected by governmental action should have standing to challenge that action if it is judicially reviewable. On the other hand, the rule on exhaustion of administrative remedies, which applies only to the quasi-judicial function of the agency, and the ripeness doctrine, which applies to the legislative or rulemaking function have different requirements for their applicability, and we don't have time to go into a detailed discussion on this matter due to the constraint of time. But these doctrines, however, share a common ultimate objective, which is the prevention of the premature resort to the courts. The other major issue concerning the scope of judicial review brings into focus the substantial evidence rule in the review of agency decisions. Under this rule, if the findings of fact of agencies exercising quasi-judicial functions are supported by substantial evidence, the courts will no longer review such findings. The rule is based on the respect that the judiciary bestows on the specialized knowledge, skills, or expertise of the agencies which judges may not likely possess. In determining the substantiality of the evidence, the Administrative Code of 1987 reflects the lesson learned from the American case of Universal Camera versus National Labor Relations Board, that the entire record of the case must be considered as a whole, not just the records developed in the commission proper, but the entire record from the very beginning, including the proceedings, the transcripts, and all documents that were presented at the level of the hearing officers or examiners, must be taken as a whole by the reviewing court. The findings of fact of the agency shall be final except when specifically provided otherwise by law. That is what the Administrative Code provides. The application of the substantial evidence rule in the review of agency decisions effectively narrows down the scope of review into questions of law and jurisdiction. However, this does not preclude the courts from reviewing the evidence on record if the substantiality of evidence is questioned. It must be emphasized that a decision cannot be based on not based on substantial evidence is a violation of due process. Hence, raising a question on the substantiality of the evidence supporting the finding of the agency, in effect, raises a question of law. In this connection, a unique situation can arise concerning the application of the substantial evidence rule. It must be emphasized that evidence to be substantial need not be preponderant. Of course, preponderant evidence necessarily is substantial. Consequently, there is always the possibility that in a given case, both sides of the controversy may be supported by substantial evidence. When this happens, however the agency decides the case, its decision is supported by substantial evidence. Something that cannot happen in a civil case because the evidence preponderates only in one side. Or even in criminal cases in which the quantum of proof is more strict, proof beyond reasonable doubt. And if this is so, if the agency can decide with substantial evidence by favoring either side, this precludes the court from reviewing its findings of fact. You remember the Banco Philippine case, which up to now is ongoing. What I call the mother case of the Banco Filipino case. When this case happened during the time of Jobo Fernandez, you will recall that during martial law. Right. That was a high-profile case. That was, you know, I could still remember the jingle of Banco Filipino, subok na matibay, subok na matatag. Right? But then suddenly, there was a kilometric line of people wishing to withdraw money, and that created a problem. And Central Bank, if you recall, had an exposure of more than 4.5 billion to Banco Philippine. You know, I mentioned this case because of what I have just stated, that in an administrative case, it is possible for both sides to be supported by substantial evidence. You will recall, if you take a second look at that case, it's a very interesting case. The holding of the majority through Justice, I think, I'm not sure now if it was Justice Bidin, was that the decision of the Monetary Board that Banco Filipino was insolvent, it was a question of solvency, on that particular date, right? According to the majority, was not supported by substantial evidence. And therefore, it violates due process. And therefore, the certiorari power of the Supreme Court can come in through Rule 65. We all know that. But you recall also that, well, maybe our women justices here can be proud of this fact. 3 women justices at the time dissented. Justice Vereda Ruth T. Romero, former director of the Law Center, Justice Morfina Vilencio Herrera, and Carol Grino Aquino. They dissented. And in their view, there is substantial evidence, according to them, to show that on that day that the Monetary Board issued that disputed resolution, Banco Filipino was insolvent. I will not go into the details of the arguments of both sides, but I mention this because of my earlier comment that if you take an administrative case like that case of Banco Philippine, that was an administrative case handled by the Monetary Board. It is possible that both sides could be supported by substantial evidence. Therefore, either way, the Monetary Board should have decided can be said to be supported by substantial evidence. And if you apply the substantial evidence rule in the judicial review of agency action, the Supreme Court should have been precluded from reviewing that decision of the Monetary Board. But this point was not raised at all in the proceedings before the Supreme Court. I wonder how the Supreme Court would have reacted if this kind of argument was presented. Because you know very well, I go back to my previous statement, substantial evidence need not be preponderant. In fact, our Supreme Court is one to add another line because the definition of substantial evidence, by the way, is of American origin. This is not Justice Laurel's formulation in Antiba. He picked this up from an American case. So the definition says, substantial evidence is such relevant evidence which a reasonable mind will accept as adequate to support the conclusion. And then our justices add a qualifying mark, even if other reasonable minds opine otherwise. That is the Philippine contribution. The American formulation stops at which a reasonable mind will accept as adequate to support the conclusion, period. Right? All right. Perhaps the justices thought that, well, anyway, it's possible to have substantial evidence on both sides, so let's put another sentence. Even if equally reasonable minds opine otherwise. Right. Now, remember, the question of substantial evidence is not only preponderance, but on, quote-unquote, adequacy of evidence. What is adequate to Justice Marina may not be adequate to Justice Paul. And they are of reasonable minds. They are justices. You cannot say that they are unreasonable minds. But reasonable minds can agree, can disagree, rather, on what is adequate. And that is what the 3 women justices pointed out. We think that there is substantial evidence. But this kind of argument was not raised in the Supreme Court. And now the case, which is still ongoing, this spillover is still ongoing. In rulemaking, before I go to the concluding portion, in rulemaking, the courts assume a posture of self-restraint and refuse to intervene unless, of course, the rules are challenged to be ultra vires or outside the scope of the rulemaking authority delegated to the agency or in cases where the rules are inconsistent with either the law or the Constitution. This attitude of self-restraint simply follows the prevalent notion that policy making in general is non-judicial business. So, we are now on the concluding part of this lecture, and I started this lecture by saying that the emergencies of administrative agencies with rulemaking and adjudication powers is a 20th century phenomenon. The question to ask at this juncture is, will the rise of these agencies continue in the 21st century? The obvious answer is a clear and resounding yes. Surely, the inadequacies of the traditional executive, legislative, and judicial organs of the state in terms of lack of time, expertise, and organizational aptitude to effectively deal with the problems associated with the complexities of modern life will not disappear in this century. As we have seen, it was precisely these inadequacies which compelled the delegation of rulemaking and adjudication powers to administrative agencies. The stark reality, therefore, is that as our society becomes even more complex in the coming years, reliance by the state on regulatory agencies will definitely increase. The expected proliferation of regulatory agencies in the 21st century is a foregone conclusion. The volume of rulemaking and adjudication will be unprecedented and will, in all probability, be far greater than the expected volume of legislation in Congress. Rules and regulations of varying kinds and with the force and effect of law will practically cover most, if not all, of our activities as citizens of a more complex society. Accepting the inevitability of more administrative rulemaking and adjudication in the future should prompt us to adopt a perspective that will enable us not only to understand and appreciate the critical role of regulatory agencies in modern-day governance, but also to realize that the uncontrolled exercise of administrative power can run roughshod over our rights as citizens. It is in this light that the continuing effort to search for safeguards that could maximize fairness in the administrative process must be viewed. Although significant strides have been made in this direction, there is always room for innovative approaches and strategies. There is no doubt that the expertise of regulatory agencies has substantially contributed to good governance. However, it is well to be reminded that, and I'm quoting the famous dissenter, Justice Douglas, unless we make the requirements for administrative action strict and demanding, expertise, the strength of modern government, can become a monster which rules with no practical limits on its discretion. Absolute discretion, like corruption, marks the beginning of the end of liberty. Unquote. As stakeholders in the administrative process, we must therefore be vigilant to ensure that administrative rulemaking and adjudication be kept within legal bounds. Maraming salamat po. If you have any questions, more than willing to answer.
Welcome to the open forum. We have microphones on the side and at the center. Please keep your questions to 1 hour. Yes, please. Well, actually, I have class cards here. By the way, some people wanted their names to be mentioned. Grace and Angel. Di Barong is from Shumar. Any questions? Yes? Anyone? I hear someone there. Okay. Yes, sir. Yes, sir. Former Assistant Solicitor General Purvis Tondo. Thank you, sir.
Good afternoon. I am 1 year ahead of Professor Carlota. I belong to the class 64. Now, my problem about this investigation, Professor Carlota, springs from my worry about administrative agencies like the Land Transportation and the Land Transportation Franchising Board as a regulatory board. Because at present, one of the parties that consulted me in this particular case, the problem here that is being raised is that what the LTO is doing, LTFRB is doing, may not be known to LTO. Like for example, I'll give you an example. In franchising, for example, if you want to franchise a jeep, Pasada from UP Campus Alba, then you are granted that franchise that is supposed to be registered in the LTO. See, because that should be the procedure. Unfortunately, I think somebody thought of a very bright idea, which is now called the interconnectivity, to build a computer in order to register this, so that para may database and all these things. So there is now a quarrel because the certain provider for this random came into it. Then suddenly there was a problem. My question actually will be like this. With two agencies like this regulatory under the same Department of Transportation and Communication performs a function which in law is supposed to be with public interest, and yet the end result is that it affects the public. So, how would we relate your lecture on these trends, rulemaking and adjudication?
Well, we go back to the basic premise that all these regulatory agencies exercise powers in accordance with their enabling charters. And therefore, if they take an action which is outside the scope of their authority, that can be successfully challenged as being ultra vires. It would be a different matter if these agencies are given concurrent authority to do certain, to take certain actions. So you would have to look at the provisions, the charters, the enabling statutes pertaining to the LFTRB, Land Transportation Franchising Regulatory Board, and the LTO, which as you said, they are under the Office of the Department of Transportation and Communications. If the authority of one or the other is exclusive on the matter of, as you said, registration of the franchise. Because if it does, well, we just have to apply the law. I mean, there's no need for interpretation. Which is it's exclusive to the exclusion of all others. So it's a question of clarification. And if upon investigation it turns out that that is something that can be allowed under the delegated authorities to these two agencies, then the conclusion will be otherwise.
Second question, Professor. I'm from the Integrated Part of the Philippines, General Council, together with our National Secretary, Attorney Tomas Prato from the IPP. We received the invitation, so we came over here. So that you will know that since you are an IPP member of the Integrated Part of the Philippines, recognizes Professor Carlota on this matter. And I was telling our incoming President, Juan Duarios also, was 85 years. We might include your lecture in the journal of the Integrated Part of the Philippines. My second question involves the Department of Local Governments that implement the creation of cities. That's why this is a second problem.
Yes.
I think everybody knows that 16 cities were legislatively created by the Congress of the Republic of the Philippines. Then when it was questioned by the present cities on the simple issue that their IRA said their amount of taxes will be reduced if there will be more who will participate, the Supreme Court ruled firstly that it is constitutional. Then, on a motion for reconsideration, the Supreme Court flip-flops and says na, hindi pwede yan. Because the requirements for a city must be as follows, as provided for by the Administrative Code, which you mentioned 1897. Like, you must have a population of at least 250,000. But the town of congressman there, represented by a certain congressman, doesn't have that number of residents. Then later on, Professor, on a second motion for reconsideration, which is supposed to be a prohibited pleading, I think all the law students will understand that. The Supreme Court flip-flops and reverses it. Now, I'm not interested in the flip-flopping. I am more interested on the execution portion. That's why I'm asking you the relevance of this lecture on that matter, because the Department of Local Government, there is an agency there that determines how much each city should be sharing in the budget.
Okay.
So,
That's a very good question. There are two matters that you raised. First is the flip-flopping of the Supreme Court. By the way, it is not just in this case that the Supreme Court has flip-flopped. It has flip-flopped several times. You also remember the PLDT case, where by the first decision it was 8-7 in favor of PLDT on the matter of the International Gateway Facility, IGF. But on the motion for reconsideration, this time the group of Justice Toy Feliciano was able to convince the rest of the court to change their mind. So it was another 8-7. So 8-7 for the first, it flip-flopped another 8-7. In rulemaking, I tell my students the Supreme Court has flip-flopped also. So this is not uncommon, Rudy, in the history of our Supreme Court. But let me tell you that there is one former justice, I'm referring to Justice Vic Mendoza, who is of the view that motions for reconsideration should be prohibited in the Supreme Court. I think he told me that in the United States Supreme Court there is no such thing as a motion for reconsideration. This is the final court that says the buck stops here. This is our decision. That's it. That's the rules of the game. There is no further road to travel. So I don't know how the Supreme Court will respond to this idea of subjecting to a second sober look this matter of first motion for reconsideration, second motion, third motion, so many motions for reconsideration. That's the first. Second, you said, well, this is more with regards to execution of the law. And my short reply to that is, regardless of our opinion on the merits of the last flip-flop of the Supreme Court, whether we agree or disagree, well, that is part of the law of the land. And if it is part of the law, that is what first-year law students are taught in law school. Decisions of the Supreme Court, until overturned, is part of the law of the land. And all the governmental agencies, the executive branch, the bureaucracy, is bound to recognize and apply that decision. And therefore, the ILG has no choice.
Any other questions from the students? Anyone? I think there is substantial evidence that there will be no further questions. So let us give our lecturer, Dean Salvador. Thank you very much. We have food outside. Thank you.